Well, ultimately, someone decided that this board was wrong in not allowing us a continuance to present witnesses, and that's why we're back here.
That's not what the commissioners decided. They did not decide this board was wrong. What they decided is that, given the sensitivity of the issue, and the fact that the objectors felt like they hadn't been heard, that they should be given an opportunity to present a case in full.
And that's what we're trying to do. And that's what we're trying to do, and we should be allowed to do that. If the board decides in the future...
Listen, Mr. Citrick, this discussion's over. We've had this discussion. You've had to submit briefs for months. You had 90 days to submit briefs. This issue is not open anymore. Mr. Boyd.
Chairman, the Board of Commissioners did not place restrictions on the evidence that we're able to present today.
This issue is closed, though. We were not going to hear it at the last hearing.
That's not what the Commissioners said, though. It was to be brought back for us to present expert witnesses. It didn't say as to what the expert witnesses were allowed to and not allowed to testify to.
Well, what I'm telling you is this board has dispensed with this issue. You're not reopening the issue. This issue was addressed in briefs.
And after the briefs were submitted and after the issue was ruled upon, the County Board of Commissioners determined that there should be evidence that was presented, expert testimony, and it didn't limit what the expert testimony was supposed to be. Now you're saying there was a limitation.
How is it that you can present brief after brief after brief and not have raised this issue, and now I'm asked to raise the issue?
We obviously did it, but the board said, the commissioner said that's what we should be allowed to do.
No, we are having a hearing today solely on the issue as to whether there should be a map amendment, a PUD, special use, and variations. That's what's before this board.
And that is what we're attempting to present expert evidence on, and the underlying zoning of the property is one of the standards, is one of the policies that by ordinance, this zoning board of appeals has to follow, period. It says that in the rules that we have to live by, that the applicants have to live by, and that you have to live by. I would like to hear, and I guess I'll move on if it goes otherwise, but I made my argument. I would like to hear what the other members of the board think on this issue. We're talking about maybe 10 minutes of testimony, which if this board decides not to listen to and make the same findings before, they can do so. But there's nothing prejudicial here at all to the applicant. There's nothing, because he knew about what Mr. Leonard was coming forward. There was no restrictions put on by the board.
Objection.
Mr.
Citrin doesn't know what I know or not know, Mr.
I do
Chairman.
know that he was...
And I do know what you directed us to do, Mr. Chairman, for today's hearing.
I was at the county board the same way Mr. Banks was, and there was no restrictions placed, period.
So, Mr. Citrin, you're so good that I'm almost confused as to which of us is the chair of this board. But the bottom line is, if this were a court of law, I would hold you in contempt.
Please do.
So, but this is not Article 3 court. The bottom line is, this board has ruled on this issue, and it's done. It's not open for discussion. And if you want to take that to court, take it to court.
I'm asking the full board to reconsider that.
Anyone can make a motion on this board.
Oh, this is cute.
I'm asking that this board reconsider and just open the issue of whether or not this is subject to the full plan development. That's what I'm asking this board. We've in effect made an offer of proof on that issue that Mr. Leonard would testify to. I'm not asking for the reconsideration on the final decision, but I'm asking you to take testimony on that fact which was never placed before this board.
We are going to caucus for 5 minutes.
Thank you.
5-minute break.